Barbara, let me start with, I think we're all still trying to deal with the shock of the leak itself. But now that Justice Roberts has come out and confirmed that this is actually an authentic document, even while admonishing us all to not mistake it for a final decision, what are your thoughts now with what we've seen and read?
Well, certainly the leak itself is a very significant development in the history of the court. But that aside, I think it is overshadowed by the significance of the substance of this decision. I think we all knew that there was some danger here for Roe versus Wade when the court accepted this case for argument and during the argument itself. But to see this complete 100% rejection of Roe versus Wade is pretty shocking. I think that there was some expectation that this could happen, or maybe even some thought that Chief Justice Roberts would manage some sort of compromise solution where abortion rights would end at 15 weeks as opposed to being completely eliminated whatsoever. So pretty shocking. As you say, it's not the end because there still may be some edits made, but what I expect is more of a smoothing of the edges than a complete change.
I've talked to a couple of court watchers today, people who've covered the court for some time, who don't think that this was just some rogue clerk letting this leak, that this was what baseball followers might refer to as a purpose pitch, that this was designed perhaps by a justice to kind of create movement one way or the other. Is that possible?
Anything's possible. You know, the idea of a justice undermining the integrity of the court by putting that out there is a pretty shocking scenario. But I suppose anybody in the court is a suspect at this point, from the justices to their law clerks to their staff. And it's a pretty small universe. So it is a small group of people. And, trying to speculate as to the reason, I suppose it could be those who are opposed to this decision who are throwing out a Hail Mary in hopes that there's enough outrage to change someone's views. Or it could be someone who is in favor of this decision. And to the extent that some of the justices are wavering and sticking to it, that they put this out there to try to lock in their votes so that they may not want to be seen as wavering in the face of public outrage, that they don't want to be seen as caving in. Maybe this is an effort to lock them in. So it's really hard to know what the reason is, but it does seem that because the people who had access to this are only people who are insiders, that it's hard to believe that someone, sold this to a journalist for a profit or something like that we sometimes see with classified information.
A lot of people are going back and watching the confirmation hearings of some of the current justices, many of whom talked about their belief in the power of precedent, and some specifically about the precedent of Roe versus Wade. How much should we hold them to what they said in those hearings so long ago in some cases?
Yeah, I've been listening to some of those too, Devin, and it's very disappointing, I think, to hear, because while they didn't literally commit to never overturning Roe versus Wade, they did say that they saw it as settled precedent, that not only were those decisions made, but many other decisions since those cases were decided have been built upon them. And so I think that their testimony, even if it was not literally false, was misleading at best. And I think that that does not put the court in the best light when public trust is such an important part of the work of the court.
If this overturns, does it matter that is it just the same if any precedent is overturned? Or to an untrained eye like mine, you're overturning a decision that was 7-2, which means it was not close in 1973. Does that matter?
I think it does matter, Devin. It also matters because when you think about why precedents get overturned, there are actually some factors justices are supposed to consider when overturning precedent. And it's happened sometimes in our nation's history. Plessy versus Ferguson, separate but equal, was overturned with Brown versus the Board of Education. But the factors that courts are supposed to look at are whether the facts and the law have changed since that other decision was made, whether other cases have developed around this law such that it no longer makes sense, whether people have relied on this decision in making their own decisions in their own lives. And based on all of those factors, there's really no basis to overturn Roe versus Wade. Really, the only basis that appears is the makeup of the court, that we had different justices in 1973 than we have today. And as you say, it was a 7-2 opinion with 5 Republicans. I think it just shows how much the Republican Party has changed since 1973.
Lastly, what do you expect legally ahead? And if you had a crystal ball, we'd figure this all out and go home. But what do you expect is coming?
Yeah, I sure don't know, but if I were to speculate, I'd say something close to this opinion will come out later this spring or summer, May, June, July. It may, tone down some of the strong language in it, but I don't think we're going to have a change in view. I think this is going to be the opinion that goes out. I think that we have something like 13 states that have trigger laws that will immediately go into effect. Those were states where laws were passed after 1973 to say if Roe is ever overturned, we will ban abortion. Those laws will be triggered. And then we have about another dozen states like Michigan that has pre-existing laws on the books. We have a 1931 statute that made performing an abortion a felony. That law became moot when Roe was decided in 1973. But once Roe goes away, that statute arguably is resuscitated back to life. I know Governor Whitmer has filed a legal challenge to that lawsuit saying that it violates our state constitution. So I imagine that will have to be litigated. And then, of course, our state legislature and the state legislatures of other states could just pass a new law that bans abortion based on this Roe versus Wade decision. So I think we're going to see a lot of shakeout in the months and years to come. And I also think that this leaves vulnerable to legal challenges many other rights that are based on the same right of privacy that was decided in Roe. Those are the rights to interracial marriage, the right to same-sex marriage, the right to use contraceptives, and other rights that are based on that right to privacy.
All of which Americans expect to be sort of sacrosanct at this point now. And in fact, when we look at polls, 3/4 of Americans, including those 3/4 of Michiganders, believe that Roe versus Wade should stay on the books. But I'm going to assume that you don't believe it's the job of the Supreme Court justices to be taking the measure of public opinion.
That's right, because sometimes the public favors things that is unconstitutional. Sometimes the public wants to ban books or flag burning or other kinds of things. And the purpose of the Constitution is to safeguard those rights even when they're unpopular. But there is one part of that that does matter to the court. And I think that is the part where we talked about overturning precedents. One factor the court should consider is the extent to which Americans have relied on that decision in making decisions in their own lives. And I think for any woman of childbearing age, this law that has been on the books for almost 50 years has been the way that people have ordered their lives. And so I think for that reason, I think there is some value in thinking about the way that Roe has governed American life for the last 50 years.
Barbara, I so appreciate your thoughts on this. Thanks so much. I appreciate it.
You bet, Devin. Thank you.